Well, hello. My name is Stephen Sanders. I'm here with Nate Cade. We're attorneys at the Green Law Group. We're here to present the 10 traps to avoid when signing a new contract. We're also going to give you a bonus 11, which is an escalation clause issue. So the topics that we're going to primarily cover, relate to when you're going to contract, but they also should be considered when we're bidding. This seminar is supported by our various sponsors. We appreciate their support and the good things that they do for our construction community. We are not here to give legal advice. If you're considering any of these issues and you want to actually kind of apply this to your situation, some of the general information topics we're covering, we advise you to retain a qualified construction lawyer and preferably our firm. So in terms of legal advice, we're not giving any here today. Primarily, we serve as a law firm contractors and others in the real estate and construction industry. We also do employment work as a firm, particularly because contractors and others in the real estate industry have employment needs. So we serve those as well. We also do corporate setups. We have represent clients as creditors in bankruptcy and other issues as well. So I'm the handsome guy there in the middle. And Nate is here with us as well. And basically, in talking about the traps in executing, before you execute a contract, the prime contract between the owner and the general contractor is a risk shifting tool. The owner wants to put certain economic and legal risks on the contractor where they're going to do work, with the assumption generally that the general contractor is going to pass those risks on down to the subcontractors that they hire. When a general contractor or direct contractor does work for the owner, they take on whatever those risks are for the work that they self-perform. They have no one to pass them to. So, so a contractor, particularly a general contractor, needs to decide very carefully what they're going to self-perform versus what they're going to subcontract out. And we encourage them to consider all kinds of factors in doing that, including insurance, risk of defects, qualifications of the general contractor and their personnel to actually perform the work they're being asked to do. So avoiding the traps means that you have to understand the risks that you're dealing with. You have to, self-evaluate what your capabilities are. You have to read the contract and understand it. If there are terms in a contract as a prime contractor, particularly where you're receiving one from the owner or the owner's counsel, you should strongly consider having your own counsel, particularly on projects, 6-figure, 7-figure projects in particular, or greater. Having your counsel review that contract, a half hour, an hour of that counsel's time can save you a lot of money down the road. And we do that for our contractors and other real estate professionals frequently. So the prime contractor is typically going to pass indemnity on to the subcontractors. They're typically going to pass certain dispute resolution provisions that we'll get into, onto their subcontractors. The payment requirements, what the deliverables are, and then the scheduling and cost requirements too, because the general contractor is making a commitment to the owner that they're going to perform on time and under budget. To the extent that there are going to be those deliverables, those also need to be the requirements in the subcontract. Now, it's also possible that those risks that will be shifted are going to be unfair to the subcontractor. Maybe, instead of having the legally valid narrow form of indemnity, maybe they're trying to pass on broad form. Maybe they're trying to pass on, pay when paid. That if the contractor doesn't get paid, the subcontractor will only be paid when the subcontractor's paid. Maybe those provisions are unfair. There may be other onerous provisions, and many of those traps Nate's going to cover in just a few minutes. But part of that process in evaluating a contract, either as a general contractor receiving one from an owner, or a subcontractor receiving one from a general, you have to understand your own bargaining power in the market that you're in. Right now, we have a hot construction market. Labor and qualified labor is hard to get. Good subcontractors are premium, so we expect subcontractors to negotiate hard and to evaluate their bargaining power and their own economic strength, and in making those choices on what contracts they're going to accept. General contractors probably should consider the realities of that and modify their prime contracts accordingly so that they can attract qualified, competent subcontractors who have means to finish their work, particularly in the difficult labor and materials market that we find ourselves in. And so that leads us to the bonus 11th trap, really two kind of in one. It's the market trap of inflation, and it's either found in material cost inflation or labor shortages. The AGC, Associated General Contractors, put out a quarter one flyer. It's 8 pages, and they go through all the miseries of rising costs and flat project pricing. They indicated that there was overall a almost 13% increase in construction costs year over between last year first quarter and this year first quarter. But there's some pretty scary spikes in particular industries, in particular materials. I mean, the fuel costs, if you're a grader, any equipment handler, 114%. Lumber, well, who doesn't use lumber? 62%, insane. Metals range anywhere from 20% up to 37%. One of them here was PVC has raised, the PVC piping has raised 270%. So, and these are spikes that are occurring even just in a matter of weeks. The other thing to consider isn't just materials costs, but it's also the lack of qualified laborers, with the COVID-19 problems, various changes in the dynamics of immigration over the last year, and the increased demand both in the residential and commercial markets, and at the same time, the backlog and entitlements at various agencies. We're seeing a pretty significant labor shortage. And, ultimately, both of these factors are putting both general contractors and subcontractors in a very difficult position, because when they sign a contract 3 months later, it may have a completely different materials pricing problem. And now they're committed to something that they can't deliver on. We've seen that on a number of occasions representing our clients. So in your contract negotiations, one of the ways you can avoid a trap is you can do what I call an equitable solution, which is, an escalation clause. There are 2 types of escalation clause. There's a delay event price escalation clause, where you set forth in the terms of the escalation clause what the trigger event would be and what the increase, would be calculated at. Those are often triggered through force majeure clauses. They may be other specific clauses as well, and it would typically be trade specific for a subcontractor, but for a general contractor, it may be triggered by an owner delay over a certain period of time in startup, any cessation, factors like that. So you may want to consider escalation clauses even in your prime contract. The other, way to deal with an escalation clause, the other option is a budget percentage change over time, where you can demonstrate through a change order that there's been an increase in a particular, let's call it lumber, increased by 25% over 90 days, which would trigger, could trigger, if you drafted the escalation clause accordingly, an increase or change order that would be justified through the contracting. These are usually tied either to an actual price quote or a cost index. General contractors maybe would be looking to cost index because there's, particularly lump sum contracts, because there's, specific materials costs may not be in the budget. So, it's hard to argue for it if you don't. So your choices are, if it's a specific material, there's a specific contract cost, you can demonstrate an actual increase, and that would be one way to trigger it. The other way would be through some published cost index. When in doubt, use both. Okay, and you should also consider substantially increasing to reflect the current market realities your fee, or including contingencies in your fixed bidding, express contingencies. You can also consider buying materials futures, and you can obtain deposits for price locks for materials, but make sure that you don't violate, if you're a home improvement remodeler, don't violate the code, restricting your initial deposit, but you can certainly get deposits for price locks, after the initial deposit, as long as that money is earmarked and paid to material providers. So that's pretty much the end of my presentation and a general introduction. I'm going to turn it over to Nate, and he can take you through the 10 traps that you would avoid.
Good morning. So like Stephen was saying, contracts are risk shifting tools. So much of my presentation here today is kind of targeted towards subcontractors, but of course, if you're a general contractor, when you consider the risk shifting function that a contract serves, you would want to shift the risk the other way. So if, a subcontractor wants less risk, obviously the prime contractor wants to pass more of that risk onto the subcontractor. So I'm going to be going through a few, traps in contracts, and I'll be explaining them with real-world examples from contracts that I've helped negotiate. So the biggest one is agreeing to terms you don't know, and I see this all the time. A subcontractor will come to me after they've been sued or they haven't been paid, and I'll look at their subcontract, and of course it will incorporate the prime contract and a bunch of other documents that become, the contract documents. And a lot of times, subcontractors, they won't even have read the prime contract, which means they're agreeing to terms in their subcontract by incorporation of the prime contract that they've never even read. So the biggest thing is make sure that, you actually have all the contract documents. Here in my example, this is just a screenshot. On the very first page of a contract, it says the subcontract documents or the contract documents are incorporated herein. But then you have to go all the way down to page 54 to find the definition of contract documents, and we have that here. And of course, it includes the prime contract, plans, specifications, etc. So before you sign this subcontract, you want to make sure that you have not just the subcontract and your bid set or whatever, but you want to have all the contract documents and review them and determine how they impact your scope of work. So to avoid this trap, make sure you get all the documents, carefully review them, and see if there's anything in there that would affect the terms in your subcontract. Another big one is not having the right to stop work for non-payment. We see this a lot. Typically, the heading might say something like no delay, like this example here. But if you read this provision, what it basically says is that you have to keep working no matter what, even if you don't get paid. So obviously, unless you can afford to finance the whole project without a progress payment, that's something you want to avoid. You want to have the right to stop working, quit the job. Maybe it's a temporary suspension. Maybe you never get paid and the contract ends up being terminated based on that fact. But you want to have express language in the contract that allows you to stop working if you are not paid timely. So this is, again, a real world example here, the screenshot of the contract provision. My client came to me before they signed the contract, which is, we highly recommend, especially, you might want to set a certain value. Maybe it's 25,000, maybe it's 100,000, but you might want to pick a number depending on, your business and the size of work you do, but pick an amount. And if you have a contract over that, consult with an attorney, an experienced construction attorney, either myself, someone at our firm, or another firm with qualified construction attorneys to review it. Typically I might spend an hour or two reviewing a contract and then, putting in my suggested revisions. And I would say a majority of the time, the other party accepts almost all of my suggested revisions. Everyone's in this to make money. So, no one wants to, get held up and lose a job or have to go with a different subcontractor over disagreements on terms. So in this example, the blue language was what I added and it was accepted by the prime contractor. So, there it had a similar no delay clause that said the subcontractor had to keep working. So I added this provision that says, notwithstanding anything else in the contract, and also set a fixed date. So I'll actually get into that a little bit more. Another big one is no right to recover fees in a dispute. Legal disputes are expensive. Taking a case to trial could cost hundreds of thousands or even millions of dollars. And we'll see an example later where it did cost millions of dollars, just in attorney's fees and expert witness expenses. So the default rule in California, or most of America, is that if there's no attorney's fees provision in the contract, then by default, the attorney's fees in the event of a dispute are not recoverable. So even if you win and the other side had no defense for not paying you and you recover all the money, you get a judgment for all the money that you were owed. If you don't have that attorney's fees provision, everything you spent on lawyers up to that point is lost cost. You're not going to get them back. Other attorney's fees provisions in contracts may be limited to certain types of claims. So in this example, this is one of the worst attorney's fees provisions I have ever seen. And this was from that same contract we were looking at before, where my client had hired me to negotiate the provisions before signing. So this provision here, if you look about halfway down or a third of the way down, it says the attorney's fees are recoverable in the event of a dispute, but then it says unless the dispute is the subcontractor's payment claim, which is the most likely type of dispute that you're going to be involved in. Or if there's defects, you might get sued, but if you have liability, we advise you to settle. We're not the kind of attorneys who will just churn a file to keep billing a client when they have liability. If you have liability and you're getting sued, I'm going to analyze your liability and recommend that you settle for as little as possible to get you out of the lawsuit. But otherwise, when you're the one suing, most of the time it's going to be a payment claim. You're not paid. You hire me to go collect your money. And this attorney fees provision excluded payment claims. So avoiding the trap, here was my markups. I just took out that whole portion, excluding the payment claims, and made it a standard attorney's fees provision to the prevailing party for any dispute related to the contract. Expert witness fees are also expensive. And unless the attorney's fees provision in your contract expressly includes expert witness costs, then they will not be recoverable. Even if you can recover attorney's fees, here again, this was a real world example. That provision screenshotted from the contract. It says the cost of any binding dispute resolution procedures and reasonable attorney's fees shall be borne by the non-prevailing party. So my client in this case, it did go all the way through arbitration, all the way to a final award, and we recovered everything my client was asking for, over almost $3 million. So we got the entirety of the outstanding invoices, and then we also got delay damages for the contractor for owner-caused delays, which is a bit unusual, but it was a great result. However, in that case, it was a multi-million-dollar case, so we were aggressively litigating it, and we needed experts. I think 4 different experts for a variety of alleged defects, because it was a design build project. So there, the client incurred almost $700,000 in expert witness expenses, and even though we won on all the claims, and we also won, we did recover a big chunk of his litigation expenses, the attorney's fees, but the $700,000 in expert witness fees was not recoverable. So fortunately, in that situation, he did have the contractor did have insurance paying those expert witness costs as the case progressed, but in the end, that was a lost cost. So of course, you want to make sure that your attorney's fees provision says attorney's fees and expert witness fees are recoverable. Another big problem, particularly in subcontracts, or this can be in prime contracts too, is an undefined payment schedule. You'll see it a lot, especially when there's a construction lender in the prime contract. The owner will have a provision that says, payment is contingent upon the lender approving, blah, blah, blah. And so you don't have a fixed date of, okay, well, I issue my invoice on the 25th of the month, I should get paid by the 7th. A lot of times you want to avoid having undefined payment schedules or no right to progress payments at all. So if you don't have a progress payment provision or a progress payment schedule in your contract, the default rule is no payment is due until work is complete. Obviously, we don't see that too much with sophisticated contractors. There's usually going to be progress payments in the contract. But if there aren't, you can't get paid until the job is completely done. And then what you'll see, of course, in subcontracts is pay when paid provisions, which we looked at earlier. And there's an example here that says the prime contractor doesn't have to pay the subcontractor until they get paid by the owner for that specific invoice. But by law, even if the prime contractor doesn't get paid, then they still have to pay their subcontractors within a reasonable time. So again, this goes to defining when payment is going to be due. So I prefer to have that reasonable time defined in the contract. And typically, prime contractors will want to define it as long as possible. So there will be language that says a reasonable time is the amount of time it takes the prime contractor to pursue, his claims against the owner all the way to a final award, which could be 10 years. Normally, 1 to 3 years, but if there's appeals and there's no arbitration, it really could take 10 years for a prime contractor to collect from an owner. So obviously, the subcontractor doesn't want to be waiting 10 years as the reasonable time. So if you're a subcontractor, you want to define the reasonable time to, I'd say, definitely no more than 90 days. Here, again, real world example, when my client approached me, and the subcontract that they were given by the prime had an undefined payment schedule. So we just added a provision saying, no matter what, even if the prime contractor doesn't get paid, you have 35 days from the date of the invoice to pay. And they accepted this proposed revision just how I had it. So you want to make sure that you know when you're supposed to get paid. If you're a subcontractor, it will depend on payment from the owner, and then if no payment, that reasonable time. So you want to define the reasonable time, and then also you want to look at the provisions of the prime contract so you can calendar when payment is due. If you're submitting your invoice on the 15th, and then the prime submits his invoice on the 20th, and then the owner is supposed to pay him within 10 days, and that means the prime should be getting paid at the end of the month, and then you should be getting paid 7 days thereafter. So at the most. So if it's, if your May invoice, it's June 7th and it hasn't been paid, and you know that the prime is supposed to get paid on June 1st, then there's an issue, and you want to look into why you haven't been paid, and you want to document it. And if you have the right to stop work immediately, you want to follow the contract provisions for providing notice of the non-payment and letting them know if you're not paid within whatever time the contract has that you will stop work. Another big one, and this is for subcontractors and prime contractors, is overbroad indemnity obligations. So obviously you're going to have some indemnity obligations, meaning, if you screw up your work and it damages them, in some other way, you're going to have indemnity obligations, but they can be limited, and you want to make sure that you're not obligated to indemnify them for damages that maybe wouldn't even be recoverable. So it's typical, I mean, it's not a standard, but a lot of contracts will have a waiver of consequential damages, meaning things like interest or not interest, but it would be like loss of use could be a consequential damage. And a lot of times the contract will waive that. Well, if you're waiving your right to recover consequential damages, it doesn't seem very fair for you to still have the indemnity obligations for other parties' consequential damages. So you want to review the indemnity obligations, the indemnity provisions carefully, and make sure that the level of risk is acceptable for the profit you stand to make on the job. You might be doing a $20,000 job and expose yourself to millions of dollars in potential liability on your indemnity obligation. So you might a common limit that you see on indemnity obligations, oftentimes not in construction contracts, because unfortunately, there is, especially if you're doing foundation, there is the possibility that your work could cause millions of dollars in damage to other scopes of work. But if you can, a reasonable limit is oftentimes the amount of the contract, right? So if your contract is $1 million and you screw up, no matter what, your indemnity obligations wouldn't exceed $1 million if you had that provision capping your indemnity obligations in the contract. So you want to make sure you understand, what your indemnity obligations are, and if you have questions, I highly suggest you consult with an experienced construction attorney to help you analyze and understand indemnity obligation. Another one is a contract might have more expansive insurance requirements than you initially thought, or bid for, or costed out. So you think, oh, of course I have insurance, I'm not worried about it. I've got $1 million policy, and well, maybe it wasn't in the bid packet. Then you get the contract and they require a $2 million policy. Well, then that would be, an adjustment. Obviously, if your premiums are going to go up, then you want to adjust your contract price accordingly. Make sure you have the right policy for the job. This is a real world. I had an actual client who built a $1 million build out for a medical office, and in their policy they did this $1 million job, and their insurance policy had an exclusion for any work on medical facilities. So then when they got sued for, I think they did $1 million worth of work, and then they got sued, and the owner was alleging that they paid a follow-on contractor $1.5 million to fix their work. So they're getting sued for $1.5 million roughly, and they have no insurance coverage at all because from that policy, because of the exclusion for medical facilities. And you might be having those exclusions because your agent or your broker is, you're trying to save a few pennies on your premiums by adding in these additional exclusions. But if it's an exclusion that is the kind of work that you're doing, is excluded from your coverage, then those pennies saved is going to cost you a lot more in the long run. Another time I had a client who did excavation and drilling, and there was an exclusion in his policy for earth movement, which when you're reading the policy, you might think, oh, that means an earthquake or something. Well, if you're out there moving dirt, the insurance company is definitely going to say that was earth movement, and they're not going to give you any coverage in the event of a dispute in that scenario. Another big one, and this is, I rarely see a subcontract that has the owner information and lender information in the contract itself, even though that's actually a legal requirement in Civil Code Section 8170. It requires all prime contracts to have a space for the owner's information and the lender's information, and then all subcontracts have to have the owner's information, the lender's information, and the prime contractor's information, or some subcontracts. I mean, obviously, if you're a subcontractor contracting with the prime's information is probably going to be there. The owner's information is probably going to be there. But a lot of times there's no space for the lender information, even though that is a requirement by law. So you want to make sure that you're getting proper contact information. You're identifying who the owner is, who the construction lender is, and who the prime contractor is. And that, of course, is so that you can send a preliminary notice, or a 20-day preliminary notice. It's sometimes called. Sometimes people call it a pre-lien. It's really not the right legal jargon, but it's a preliminary notice. You're supposed to send it within 20 days of starting work on the project. We recommend that you send it as soon as you sign the contract. And then you should also be verifying that the owner and lender information that you received is actually accurate. You know, there's plenty of services out there that can give you a title report or a title summary on real property, so you can verify that the owner information that you have matches up with the record owner of the property. So yeah, make sure that the owner and lender information is there, verify it, and then send your preliminary notice as soon as you sign the contract. Otherwise, if you haven't sent a preliminary notice to all the parties that are required to receive one, then you may have forfeited your lien rights. And if you already signed a contract and it didn't have that information, go ahead and ask. By law, the prime contractor is required to provide the information. Obviously, Section 8170 requires it in the contract itself, but separately, even if it wasn't there, Section 8208 requires they provide that information to anyone who can give a preliminary notice. Another thing you want to look for is the warranty provisions. And you might be thinking, well, hey, I know that, you know, I have a 10-year warranty anyway by law. You know, that's for latent defects. And so then you might sign a contract that has a 10-year fit and finish warranty. Well, you just bought a lot more potential liability because, you know, a 1-year fit and finish warranty is what's required by the law. It's 10 years is only for what's considered a latent defect, meaning something that wasn't observable at the time that it was built, and then maybe something happens later that exposes the defect. So you want to make sure that, you know, your warranty provisions are reasonable, and that you're not guaranteeing something for a lot longer than the law requires it. You know, if an owner or prime contractor is insistent on more expansive warranty provisions, you may be able to negotiate an increased cost, you know, more payment in exchange for the more expansive warranty. So make sure that you read the warranty provisions of your contract, you understand them, and that you're not warranting more than you're comfortable with. Liquidated damages for delay. Sometimes liquidated damages is the easiest way. You know, owners like to have them because they don't have to prove actual delay damages. They just have to prove that there was a delay and that it was your fault, and then they get the X amount of dollars per day. You know, it's okay signing a contract with the liquidated damages provision, but you want to make sure that that amount is reasonable. You know, if it's a $20,000 job, you shouldn't be giving them $1,000 a day for liquidated damages. So something that would, you know, match up with basically the value of the property, the lost use of the property if there are delays. And then, of course, you want to, during the project, make sure that you're getting the time extensions that you deserve. You know, if another sub delays your work, or if the prime delays your work, if the owner delays your work, you want to document that. You want to follow the contract procedures for getting a time extension. A change order should always have two components. You have the cost component, but then you should also have a time component. There might be 0 days change orders, but you might have a change order that adds 2 weeks. So you want to make sure you're not just getting the additional money for the change order, but that your change order, when it gets signed, has the amount of days that it will extend your time for performance. That's basically what I just covered. And then the final one here is cumbersome dispute resolution procedures. You know, of course, there's mediation, which is not binding. There's arbitration, which is binding without a judge or a jury. And then there's litigation, which, you know, in court, you could have a jury, but in construction disputes, it's usually better to have a judge anyway, who knows a little bit about construction. And so you want to analyze the dispute resolution procedures in your contract, and it might be a mix and match. And you want to avoid something that's going to put you in a cumbersome situation. A a lot of times the dispute resolution procedures in subcontracts will kind of partially or fully incorporate the dispute resolution in the prime contract. So it'll say something like, if it's a dispute between the contractor and the subcontractor, then it goes to arbitration unless the dispute also involves the owner, which of course, if it's a payment claim, it usually does. Then it'll be, something else. So you want to make sure that you understand the dispute resolution procedures that you're agreeing to. Again, going back to the start, you want to, if it incorporates the prime contract, make sure you have a copy of the prime contract and you review that before you sign the subcontract. So here's a example of a real world example of particularly, it fit onto about a page and a half, the dispute resolution procedures in fine print. And it requires mediation prior to any arbitration or litigation. And if you don't participate in the mediation, you lose your right to recover attorney's fees. So when deciding whether you want a mediation provision, it's a little bit more of a complicated analysis. Not every case is ripe for mediation. So, if, for example, if you're owed 200 grand on your last 2 invoices, and the job's done and there's no defects, well, there's really, not much of a point in mediation. Now, if they're alleging that your work was defective, then it might make more sense to go to mediation because it's kind of a give and take. But you're almost never going to get, your entire unpaid invoices offered in mediation. So to have a provision like this that requires mediation for any claims and forfeits your right to recover attorney's fees if you don't participate, that's something that you may want to avoid, because then when a dispute arises, it should be, the decision whether to mediate should be able to be made on a case-by-case basis. But this example provision here doesn't allow that. This one, like I said, it's really, there's 4 parts to it. It says, like I talked about before, if the dispute involves the owner, it'll be with the owner. And you have to join in the arbitration between the owner and the prime if you're a subcontractor. And then it has, and then finally it says anything, if the dispute's more than $500,000, none of the arbitration provision applies and you're going to go to court instead. So this is one of those, it's a page and a half of fine print just for the dispute resolution procedures. And, if this were one where my client had come to me before he contracted, then it's something that, I may have suggested a modification to that. So you want to make sure you read the dispute resolution procedures, understand them, determine, to what extent, if you're a subcontractor, to what extent the dispute resolution procedures in the prime contract impact the provisions of the subcontracts, and then determine if mediation is desirable. A lot of times, I'm perfectly fine with having a contract that doesn't say anything about mediation, because the parties, once a dispute arises, the parties can then decide. You can always agree to go to mediation after the dispute has arisen. But I really like staying away from provisions that require mediation for any claim, no matter what, before you even know that there's a dispute. So mediation might not always be desirable. So it's the kind of thing that's, I think, best left on the, to analyze that once the dispute arises. And then, if the dispute resolution procedures are not acceptable, you can always negotiate for more reasonable provisions. We do usually recommend arbitration provisions, but that would be, that would be the extent of it. I would think that you would want in a prime contract with the owner, just a simple, we agree to participate in arbitration. You want to identify, make sure that the arbitration provision identifies the rules. There's the American Arbitration Association is a popular one. There's JAMS, ADR Services, Inc. There's a bunch of companies out there that offer dispute resolution, procedures, arbitration. But you want to make sure the provision in the contract identifies which rules you're going to use should you have a dispute and go to arbitration. Otherwise, it could be, there could be issues of enforceability of a provision if it's not specific enough to identify where you're going to arbitrate your claims. So that is all I have. I'm not sure if Stephen has anything to conclude or if there's any questions.
I would just say generally, particularly on the last point, it'll cost, anywhere upwards for a party, $7,000 to $15,000 probably for a mediation, sometimes more. And so if you are a contractor that's like a home remodel contractor, it's good to have a mediation clause, because you want the parties to talk to each other. But you want to make sure that you put some kind of floor on whatever that mediation process is going to be in terms of the amount in dispute. There's also project neutral provisions, which we didn't cover here, but are used particularly in commercial, public works disputes. I'm a big fan of project neutrals, but I'm not a big fan of using the architect of record, who's in the owner's pocket, as the designated neutral. I would rather just figure out somebody, maybe a competent construction lawyer that the two parties can agree on, or maybe a retired judge, and they can act as a neutral. And it's non-binding, but it can also be cheaper than a full-blown mediation with briefing, evidentiary showings, and all of that. So, on the bigger contracts, you want to consider maybe including designating a project neutral, but that'd be the only thing I'd add. So, okay.
And just finally, we're always here. There's other qualified construction attorneys. If you're ever not sure about something and it's, $100,000 I can review a contract and suggest modifications that you can take to the other side. For rarely would I spend more than 2 hours on it. So it's $500-600 at the most to have an attorney look over your contract and suggest modifications. So, maybe not for a $20,000 project. You're kind of eating into your profit there to pay an attorney a few $100 to look it over. But certainly, I have clients sometimes that will sign $1 million contracts and never talk to me about it. And then the dispute comes up and I'm like, well, I really wish you'd had me look at that before you signed it, because we could have negotiated some provisions to make it more reasonable.
Here's a good general rule. If there's bankruptcy liability for you in the contract, you should be talking to an attorney before you sign it, or you should have had enough experience talking to a competent construction attorney on previous similar contracts that you really know what you're doing. If you haven't had time actually talking to an experienced construction lawyer about how to negotiate contracts, you're probably walking into a bad place, and you may be doing it repeatedly and not even realizing it. I have lots of clients who, I've never had any problems, I've never been sued, yada, 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 until the point where they are. And we all know California is a litigious place. So, I would encourage you to at least spend some time in a few exemplar contracts, so you understand your own contract and also generally what kinds of contracts are being put in front of you. Hiring us a few times to do that is an incredible education. So, we're happy to help. I don't have any questions so far. I don't see any listed there. So this is your last shot. If you've got any questions for us, go ahead and type them in and we'll be happy to answer them. Otherwise, you see our emails there on the screen. Stephen, S-T-E-P-H-E-N at the Green Law Group, and Nate at thegreenlawgroup.com. You can feel free to email us your questions as well. Also, if you want any materials from this presentation, you can reach out to either us or the administrators, and we'll be happy to provide them. Okay, so no questions. Thank you so much. Appreciate your time. Hope this was helpful, and we look forward to seeing you again soon. Bye-bye.
Thank you.